BYJU'S exam prep. I'm Nivedita Raje, and this is the part 2 of SLAT revision, right? So this is the legal aptitude revision part 2. It's not exactly a marathon because it's not going to be a 2-hour session, right? So yes, hello, good evening everyone. How are you all? A-Lit result is out. Did any of you qualify? Anybody? Good evening, good evening. How are you all? कैसे हो तुम सब? Good evening. Good evening, good evening. So just like before, we are going to solve questions which we think are pretty relevant for your exam point from your exam point of view. Plus, they are a good revision practice, and it's always a good idea to practice as much as you can before the exam. Gives you a certain level of confidence, especially if you're scoring well. And if we have gathered anything from the last session, I am sure that you are going to perform extremely great. What is going to take place? Is it along with exams or along with the what? Agrima, I don't understand your question, sweetheart. I'm good too, Alfia. Thank you so much. I'm good. I'm good. Absolutely amazing. Fantastic. And I'm really happy that my students are giving such great performance. We have selections everywhere. Like here, there, everywhere. So it's a good thing. Okay. Yes, so okay, let us start. Question number 1. The principle is this. Bilkul, don't worry about legal, Teja. Do not. She's asking about writing ability test. Can you? Oh, you're talking about what? Writing. Oh. I'm so sorry. Can I come back to your question towards the end of the session, Agrima? Oh, why don't you post it on the portal? I'd be able to answer better. Okay, post it on the BYJU'S portal. I'll answer in detail, like everything that you need to know. Okay. Yep. So Teja, don't worry about it. You don't have to worry about legal. It is not going to be that difficult. It is SLAT. They don't make it that difficult. Okay. So this is the principal contract to do or abstain from doing anything if an uncertain future event happens is called contingent contract. Contingent contracts cannot be enforced by law unless and until that uncertain future event has happened. Okay, so these are the facts. Everybody right? Over to the options, everyone. What do you say? Facts. Options. Contract cannot be enforced, can be enforced, none of the above. What do you think? So Malika Arjun said that it is not enforceable, but we have two options. Okay, so Nippon is the first to answer and he says A. What about the rest? Come on, guys, answer. Lasya also says A. Gitanshi A. Alfia, Mahita, Kumari, Asmita. Everybody says A. Tanishk also says A. Akanksha, Puneet, Roma, Agrima. Okay. Go on. There's so many students watching. Come on, keep answering. Sneh, Sangini, Nandini. Has Tanishk changed his? Why did you change your answer, buddy? Come on, A is the correct answer. Yes, it is A. Don't have to. It's A. It's A. It's definitely A. The contract cannot be enforced by law because the house is destroyed by an earthquake and not fire. So it is indeed A. The contract is unenforceable. Very good, guys. A is the correct answer. Yes, Shinchu, it's A. Okay, so the two principles, question number 2, criminal trespass and criminal trespass. Yes, Nandini, precisely. Should we move over to the options? Everybody read it? Okay. A was the tenant in a multi-story building owned by B. Okay, read it. Classic B. Sorry, classic A. That is funny. Oh man, it's funny. Moving on. Yes. Options. What will happen? What do you think is going to happen? Poor, poor B got slapped. Kind of funny, yeah. So will he succeed or will he not succeed? A is liable. Okay, so Sneha and Akansha says it's A. Option number A. What about the rest? What about the rest? Nipun also says yes. Mallikarjun, Alfia, Shinchu, Lasya, Puneet, Mariam, Tanishk, Aanchal, Gitanshi, Asmita, Kushagra, Tanishka, Sangini. He'll succeed. Yes, Shinchu, I got it. I got it. Roma, Tanishka, it is A. It is A. Yes, as soon as the landlord tells another person or especially a tenant to vacate the property, immediately the possession that is continuing after that declaration becomes unlawful. And if you continue it, it is definitely trespass. Since he is staying unlawfully, he is not staying with a valid declaration or under a valid permission by the landlord, he is committing criminal trespass. A is correct. Very simple. Question number 3. The session started exactly at 7. I was not late. Yes, moving over to the options. Harry has not committed theft. Harry has committed theft, but he has committed it the next day. So third is he has committed the offense of theft when he moved the ring from the table. He has committed the offense of theft when he hid the ring under the carpet. Yes, Satya, you may come in. Okay, so what do you think the answer is? Has he committed the offense of theft? And if he has, when? The next day, or the moment he moved it from the table, or he hid it under the carpet? Okay, so Nandana Malika Arjun says it's B. Kushagra and Shrek says it's B. Sorry, Nandana says C along with Mallikarjun. Akanksha, Gitanjali, Mahita, Lasya, Sneh, Puneet, Nipan, Shinshu, Agrima, Asmita, Alfia, Anjali, Mariam, Tanishq says C. Shrek again says B. Ankur says C. Ananya says D. Sangini, Maharshi, Anusha, Ananya again says C. Why do you think it is C? Why do you think ये नहीं हो सकता, डी नहीं हो सकता, या बी नहीं हो सकता है थेफ्ट किया ही ना, थेफ्ट तो उसने किया है. The definition clearly says that as soon as you move that thing, right, you move that thing, as soon as the person moves it dishonestly, immediately the offense is committed if it is done without the consent of the possessor or the person who is lawfully possessing it. So as soon as he moves that ring from the table, he has committed the offense, and C is the correct answer. Very good, guys. Yes, because he took it out of the possession, C is indeed correct. C is the correct option. Very good, very good. Question number 4. Rule against double jeopardy is followed in India, which states that no person shall be prosecuted and punished for the same offense more than once. Okay. That's okay, Shrek. Options? Okay. These are your options. Can he be prosecuted for the rape of Lily and the rule of double jeopardy will not apply? Cannot be prosecuted, the rule of double jeopardy will apply. Can be prosecuted for the rape on Lily but cannot be punished for the same. वाह, ये तो अपने आप में अनोखी बात है. Cannot be prosecuted because he was convicted once before. So what do you think the correct answer is? Yes, everyone. Okay, so Aditi has answered. Aditi and Nikita on the app says your answers are correct, guys. Aditi and Nikita both. So now I have answers. Everybody is saying A. He cannot claim the defense rule of double jeopardy and he will be liable for the act that he committed. You're absolutely right. When we talk of double jeopardy, there are few things that you need to remember. Now, double jeopardy definitely talks about not punishing the same man for the same offense more than once, right? But then when we talk about the same offense, we are talking about a particular offense that was committed in one particular transaction. ओके सो एक ट्रांजैक्शन में एक ऑफेंस की एक ही सजा मिलेगी, ये रूल है. उस ट्रांजैक्शंस में एक के अलावा जो ऑफेंसेस हुए हैं उनकी अपनी पनिशमेंट है, लेकिन उस एक पनिशमेंट या एक ऑफेंस की अपनी अलग पनिशमेंट होगी और वो एक ही बार दी जाएगी. अगर एक आदमी दूसरे ट्रांजैक्शन में दूसरा ऑफेंस कर देता है तो उसका अलग पनिशमेंट है. अगर जो आउटकम था, फॉर एग्जाम्पल लेट्स से दैट ए वाज convicted for grievous hurt, right? But the man who was grievously hurt later on succumbed to the injuries and died. Now A will be given another punishment which will be of culpable homicide. It will not be grievous hurt, right? And that won't be double jeopardy because the offense has changed. Same offense, same person, one punishment. Different offense, same person, different punishment. That is what the rule says. Also, the conviction can only come from a judicial authority. Okay, only courts can order conviction. So a person is claiming this benefit, he has to prove that the conviction or the punishment came from courts, not from anybody else. Okay, for example, let's say that A was liable for sedition and prosecuted for it, and A was also suspended or terminated or from his job or college. Now he says that I'm already facing conviction in the court of law. You are terminating me. This is double jeopardy. This is not double jeopardy because the institution which terminated him from the services is not court. No, Satya. Two houses, two thefts, different transactions. We're talking about one transaction. For example, a person entered a house, committed theft, killed a person, grievously hurt a person, broke many items, and ran away. Now, in this particular transaction, he has committed a lot of offenses. He committed theft, he committed grievous hurt, he committed murder. Since he has committed grievous hurt and murder, there is an offense of robbery also, right? So now he will be committed for all, he will be convicted or punished for all these offenses together. Different punishments will be accumulated. But if he goes to a different house and commits the same offenses again, different punishment, different trial, because the parties have changed, no? So it is A. He will be punished. It cannot be C, Shrek. He will be punished for the same. The rule will not apply. If the rule does not apply, punishment is there. वन ट्रांजैक्शन, मेरी बात को आप कंफ्यूज कर रहे हैं. देखो, अगर एक आदमी ने एक, लेट्स से एग्जांपल से समझो, ए ने बी को स्टिक से मारा, उस स्टिक से उसने बी को 50 टाइम्स हर्ट किया. अब उसे 50 हर्ट्स या 50 टाइम्स स्टिक को चलाने का पनिशमेंट नहीं मिलेगा, उसे इकट्ठा हर्ट का पनिशमेंट मिलेगा. ये है रूल ऑफ डबल जेपर्डी. ठीक है, एक आदमी ने तुम्हें 3 थप्पड़ मारे अलग अलग, 1 2 3, तो इसका मतलब ये नहीं कि ये 3 अलग अलग ऑफेंसेस हो गए और इन तीनों का अलग अलग पनिशमेंट. नहीं, इन तीनों का एक ही पनिशमेंट. ये डबल जेपर्डी होती है. ओके, दिस इज, सो द आंसर इज ए. Question number 5. A makes a video of her classmate while she is taking bath. Which of the following offenses has been committed by A? Even if the principal talks about punishment, then also C is not correct. He will be punished. He has committed a different offense in a different transaction. Okay, he has committed an offense, the same offense again, but that is a different transaction, different event, different day. So punishment is definitely there. Shubhalesh, what I said was that if a person, double jeopardy means that if a person hits you 3 times, he will not be given 3 different punishments. He will be given one punishment of hurt. That's what double jeopardy is. Everybody says D? Yes, exactly. This is voyeurism. Using electronic media to invade privacy of a female in a manner that her modesty is outraged is called voyeurism. So recording something while she is in a private activity, whatever it is, while she is engaged in a private activity, an activity related to toilet or anything which includes changing or anything that shows her in a bare form while she is not decent, that is what voyeurism is. Okay, voyeurism has been defined in a certain section, and that section is section 354D. I might be wrong. Can somebody confirm? I think it is 354D. Might be C also. Outrage means to violate. Voyeurism. It's C, guys, not D. I'm sorry, I got confused. It's C. 354C. Okay? Yeah. You don't need to remember the section. As long as you understand what this offense is, it's okay. It's 354C. Yes. Question number 6. A was employed by B and also provided a house to live in depending on a condition that he'll enjoy. Okay, you read it. I won't read it. Aditi has also answered it's 354C. Yes, very good. Everybody knows except me. I don't like it. Okay. Oh, I'm so sorry. What did you answer? No, Nandini. No sections are asked. Everybody says A. It's A. It cannot. Actually, it can be D. It can be D. Yes, he can take legal recourse. He can use reasonable force. He cannot use more than reasonable force. It is D. Yeah. I also got confused. It is D, guys. D is the correct answer. A takes B's diary, believing it to be his. When he opens it, he realizes it's B's diary and not his, but he decides to keep it anyway. What has he committed? That's nice. It's D clearly. Read all the option. Termination is end of services. What kind of reasonable force? Pushing, leave my property, or shouting at him, leave my property at once. That's the reasonable force. Using the force of voice. Everybody, okay, so what do you think the answer is here? Theft. You think it's theft? It's not theft. It's definitely not robbery. And he definitely has committed an offense. It's none of the above. It's more like criminal misappropriation of property. It's not been mentioned here. So it's actually D. None of the above. Yes, it's D, guys. Moving on, question number 8. Peter was returning home from his office. Rosie, a stranger, pointed a gun at Peter, asked him to deliver all his belongings or else she'll kill him. Wow. Tough Rosie. No, this is not theft or robbery, Lasya. It's more like criminal misappropriation of property. It's very simple. I just said criminal misappropriation of property. Yeah, but he has done it without a dishonest intention. Theft requires a key element which is dishonest intention. Okay. And the facts nowhere show that it was in the possession of D. Everybody says D. It is D. It is coercion. And what she has committed is robbery. Right? Extortion converted to robbery. It's D. Good, guys. Study of jurisprudence is an opportunity. Okay, who said it? Can anybody answer? I can just move that question. I mean, you don't have to answer if you want. Who said it? I know. I know. Study of jurisprudence is an opportunity for the lawyer to bring theory and life into focus, for it concerns human thought in relation to social existence. Shubhalesh, you are in serious need of proper classes, buddy. Okay, why don't you join a course? It's important. Holland. Nandini says it's Dias. Who else? Just take a guess. You don't have to be correct. Nandini says it's dice. Everybody else says it's either Holland or Bentham. हाँ तो क्रिमिनल मिसअप्रोप्रिएशन में भी डिसऑनेस्ट इंटेंशन होता है लेकिन मूविंग के टाइम पे नहीं होता है. पढ़ाऊंगी मैं क्रिमिनल मिसअप्रोप्रिएशन, पढ़ाऊंगी मैं, तुम समझ जाओगे. मूविंग, अगर तुमने मूव किया है डिसऑनेस्ट इंटेंशन के साथ पोजेशन से अलग तो थेफ्ट है. यहाँ पे पोजेशन दिख नहीं रहा है ना, उसने वहां से नहीं उठाई कि उसके पास रखी हुई थी, उसने ऐसे ही उठा ली, वो बी की थी. नाउ यू से सामन, इट्स except Nandini, nobody is correct. It's actually, oh, Anjali is also correct. It's dice, guys. Dice said it. You need not remember it. इसको याद रखने की या रटने की या इससे रिलेटेड कुछ भी ढूंढने की एकदम जरूरत. यू नीड नॉट डाइव इनटू क्वेश्चंस लाइक दीज. These are some extremely difficult and unexpected questions. It's dice, yes. Okay, he gave the theory of rule of law. Okay, rule of law. He gave the theory of rule of law, which has been incorporated in our Article 21. It's dice. You need not remember it. It's one of those questions. One of those questions that who's who everybody gets wrong except few like Anjali and Nandini. Yeah. What does the maxim actio personalis moritur cum persona mean in law? Yes, Nandini, I said your name out loud, sweetheart. Yes, we have discussed it so many times. Personal right of action dies with the person. Personal right of action dies with the personal laws. Does not die with the person. Transferred to legal representatives. What do you think the answer is? Yes, people. Okay, so Nandini and Lasya says it's A. Malika Arjun says it's C. Rest everybody. Khushi, Ajitesh, Nipun, Puneet, Kavita, Shrek, Maharshi. That's a good name, Maharshi Vyas. Is that your real name? Kushag, Gitanshi, Rosie, and Shrek says it's clearly A. Well, if you are so confident, who am I to deny you a correct answer? Yes, it is A. Personal right of action dies with the person. That's true. What does it mean? It pertains to a civil action. So if a person has a civil action or a civil cause of action, which means that if a person's civil right is violated, he can claim a remedy. This entire thing is called cause of action. The reason why a person sues is called cause of action. Now, in the civil law, this right or the cause of action is limited to the person whose right has been violated. So let's say if my civil right is violated, only I can claim the remedy. My child, my husband, my father, my mother, nobody else can go to the court and claim the remedy on my behalf. So if I die and the remedy is not given to me, the entire process also becomes redundant. Why? Because the person who were to avail the remedy is not existing anymore. तो अब remedy कैसे दोगे? बंदा तो मर गया. ठीक है, तो इसीलिए केस को डिसमिस कर देते हैं और यही इस मैक्सिम का मतलब है. Okay, actio personalis moritur cum persona. Personal right of action dies with the person. Very important maxims. I think we have two more. Satya. Quasi contract, fictional form of contract recognized by a court. There are various conditions necessary to be fulfilled in order to yay. Yes. Is not a necessary condition. Please don't miss this word. It's very easy if you apply logic. You know what quasi contract is, you understand the concept. There's only one option which seems absolutely out of place. Which option is that? Rosie says, okay, Rosie has retracted her answer. Kushagra says it's D. Alfia Satya says it's A. Nipun says it's B. And Kushi also says B. Kidanshi says D. Lasya says C. What about you, Nikita, Aditi, Leena, Shiva? Aditi says it's B. Okay. Who else? Anybody else willing to answer? Leena says it's D. Guys, it's C. Come on. It's C. What exactly are quasi contracts? Quasi contract is a fictional contract created so that one party does not suffer a loss. The classic example of a quasi contract is, let's say that I am visiting you on Diwali and I have many boxes of son papdi. One of the boxes, I give you one box and rest I'm supposed to leave. Oh sorry, I'm supposed to take with myself because there are other people जिनको मुझे मिठाई देनी है. Now, accidentally, in a missed confusion or something, I accidentally leave all the boxes at your place and you consume all of them. Now, the thing is that there is no previous obligation between us. Okay, there is no previous obligation between us. There is no agreement as to what would happen if I were to leave any mithai ka dabba at your place. There's nothing of that sort. But if I'm not reimbursed, I'm suffering an unnecessary loss and you got an unnecessary advantage or an unjust enrichment. That is why law steps in and creates a fictional contract so that I don't suffer a loss and so that you don't get an unjust enrichment. That is what a quasi contract is. Now, what is the necessary condition to invoke a concept of quasi contracts? There has to be an unjust enrichment due to the receipt of a benefit. This is necessary. The enrichment took expense of other party. Now if I leave all the boxes at your place and you utilize all of them, you are doing it at my expense. I paid for them, you did not pay for them. That is why every enrichment that happens in a quasi contract happens at the expense of the party who is suffering a loss, right? And the third condition is that there is no previous obligation between the other parties. That is why a fiction is created. If there had been a contract, there was no problem, but since there was no obligation, no understanding, that is why law has to interfere and create a fictional fantasy contract altogether, right? That is why, exactly, Nandini, this is a principle of equity. And this is why C is the correct answer. It is important that you understand what quasi contract is. Next year, CLAT, I am expecting a question from quasi contracts. Let's see. If it does come, I am going to use it. See, I told you so. So, what is the maximum locus stand? I mean, Lena, sadly, I don't. Locus standi. The thing that I just explained to you is directly related to this term. Rosie, 15 to 20. Might be more. Can be anything. Okay, so Anadi, Mahita, Kushagra, Gitanjali. Yes, Ananya, it can never be just. It is called an unjust enrichment for a reason. It is A, yes. the right or capacity to bring an action to appear in court. So if a person gets the right to sue, to institute a legal action, that is what we call locus standi. PIL or public interest litigation is an exception to the rule of locus standi. What does this statement mean? This is your homework. ठीक है? Public interest litigation is an exception to the rule of locus standi. What does this mean? Do this homework, research why did I say this or why did Justice Bhagwati said it, and find out the answer. We shall discuss the answer tomorrow in our next class. Till then, everybody has to take very good care of themselves since you have an exam day after. A is the correct answer. You can follow us here on Telegram, Instagram, Facebook, and you can also download our app. About the YouTube thing, you're supposed to like this session at you have to like it. There is no but, there is no pause. You just have to like it. Okay, that's an imperative rule of attending my classes. Like it, share it, comment on it, and also subscribe to our channel if you haven't already, and press that bell icon which is there so that you get the notifications of whenever we are live or conducting a live session. Okay, everybody, take care. I shall see you again. Ria, I don't think we have enough time because SLAT is day after. I think you need 1 day of break also. So you are prepared enough, don't worry. MHCT, yes, Kashish, I do teach for MHCT. In fact, BYJU'S has different programs for MHCT. You can ask the counselors, right? We will call you. Everybody take care. We shall see each other tomorrow also. That's a general session, not related to any concept. All the best for your exam. इसी तरह से perform करो. Your preparation is outstanding and I'm sure you're going to qualify. Everybody, bye-bye. Take care. Thank you so much for being so amazing.